Welcome back, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I am the CEO and founder of SERMA, Rich Lenkov, and I am really pleased to present a great guest, Caitlin Kovacs from Benesch Law. Caitlin is a litigator and partner with a firm. She specializes in defamation. She was recently quoted in Variety discussing the Blake Lively, Justin Baldoni lawsuit, feud, conflict, whatever you want to call it. There's been lots of drama surrounding this drama of a film. Caitlin, welcome to the SERMAPod.
Oh, thanks so much for having me. I'm really happy to be here.
So I just finished watching the film over the weekend, and you and I were talking offline about the film, and it's really hard to watch it without sort of thinking about some of the accusations that have been leveled by each side. So let's get into sort of what's being alleged, and then we'll get your thoughts on the future of this litigation. But basically, I'm sure most of our readers and listeners have heard of this lawsuit. But what's being alleged by Justin Baldoni, who is the director? I believe he's probably a producer. He could be a writer as well. He's also the male lead of this film. The film is called, by the way, It Ends With Us. And it also stars Blake Lively, who is also alleging that Justin Baldoni mistreated her during this film. So tell us briefly what the allegations are between these two parties.
Sure. So it is kind of hard to keep it all straight because there are actually four different litigations, one of them with an asterisk next to that. But the first one was filed by Blake Lively in California with an arm of the government, the state government, that's meant to be sort of an alternate dispute resolution alternative. And those kind of complaints that can be filed will often stay confidential unless someone else gets a hold of them. So that was the initial complaint that we saw from her, and the focus of it was really on sexual harassment and retaliation. And that's the complaint that formed the basis for the article that the New York Times released that kind of started all of the press around these issues in fall of last year. So there's that initial complaint. And then we have three other litigations that are now sort of actively going forward. There's the litigation in California where Justin Baldoni and a number of other people have sued the New York Times for publishing that article. And they've sued the New York Times primarily for defamation. And that's going on in LA County. And then there are two other litigations happening in the Southern District of New York. So Blake Lively has sued out there Justin Baldoni and a number of other defendants for this essentially the same claims. I think there might be one or two that are different as what she asserted in that first complaint. And then Justin Baldoni and his team are also suing Lively and a number of other defendants for defamation out there. Both of those litigations are being overseen by the same judge. And I think he just announced that he's going to consolidate them into one case. But the crux of Baldoni's claims are for defamation, both against the NYT and against Lively and the other defendants there. So they both have a number of causes of action, I think maybe up to 10 or so, but Lively's remain essentially harassment and retaliation, and Baldoni's are based on defamation primarily.
Let's get into the defamation claim first against the New York Times, because they've come out and said that we plan on vigorously opposing this claim and that they stand by their reporting. How does one go after a publication such as the New York Times, which is presumably reporting the story and not adding their opinion, although I'm sure Baldoni's side says that that's not what happened. So break that down for us and give us your thoughts on what that liability could look like.
Yeah, happy to. It is really challenging to bring a defamation suit against a news organization. We have decided as a country that we care very much about free speech. We care very much about the public being properly informed about news events that affect them. And anything that has to do with, the public interest, which is defined very broadly, we put stronger protections around suits that have to do with informing the public about those issues than we do about other lawsuits. So in California, there's what's called an anti-SLAPP statute. that will apply to this case, I'm sure, which says that when you bring a suit against someone for what we consider to be important free speech, like what the New York Times put in their article, you have to you have to meet a higher standard in your initial complaint to get to the discovery stage. So Baldoni's team will have to show that their defamation claim against New York Times has a substantial basis in fact and law. Usually, you just sort of have to allege facts that look like a claim. And if if the court says, "Hey, those are facts that look like probably they would justify a claim," then we can go forward. Here, what Baldoni's team is going to have to do is not just allege those facts, but kind of start the process of proving them up a little bit, not to the same extent they will have to do at the end. But that's part of the reason you see such an extensive complaint from them, is because their burden is going to be higher here. Then what they're going to have to show is that the New York Times published a false statement. They have to be really specific, right? Defamation is statement specific. It can't just be, oh, they said a whole bunch of bad things and that affected my reputation. They have to point to a specific statement, say that was false, and then further prove that the New York Times, when publishing that statement, knew that it was false, or they acted recklessly in publishing it without first confirming that it was true or false. So not just like negligently, like maybe they should have done things differently, but reckless is a higher standard. So that's what we call kind of the actual malice standard or the fault standard. And that is hard to prove, right? Because usually if what we see organizations publish, they're spending some time, hopefully, if they're doing their job, confirming that what they're publishing is in fact the case. And then separately, they're going to have a hurdle here with the fact that the New York Times was reporting on a legal complaint. There are a lot of privileges that go along with reporting on sort of a legal action. And so that's going to be a higher burden for them too.
Caitlin, in the last couple of months, but more specifically in the last couple of weeks, we've seen litigation against major news organizations result in settlements. Specifically, I'm talking about Trump, President Trump's allegations against first ABC News, where they agreed to settle the claim that George Stephanopoulos made a misstatement in describing what Trump did. Number two, we heard last week that Trump settled his lawsuit with Meta, known formerly as Facebook, involving, I think, a $22 million, or maybe it was $25 million, of which $22 million is going to the Trump library. There's also rumors that Trump's lawsuit against 60 Minutes and Paramount and CBS is going to settle for a substantial amount. In this climate, are these allegations against news organizations like the New York Times here, albeit in a different area, but are they now easier to bring and making it harder for these news organizations like the New York Times to defend themselves?
That's a really great question. And I think a lot goes into the consideration about whether to settle a lawsuit or go forward. These lawsuits can be very expensive. They're very drawn out. There's a lot of discovery that can be had because, like I described earlier, the plaintiff has the burden to prove what was going on in the minds of the people controlling the publication at the time. And so that means that you can really get into people's internal, their personal text messages. You can get to their communications with their friends. It's not just limited to sort of what's going on internally on the work computers at, for example, the New York Times. And so we also see what's going on in public right now. And there's just so much PR that's getting generated from these cases. So I think in an environment where we've just had President Trump start his new term, and he's sort of declaring that a lot of things about our culture that had been growing, had been in place, and had been being pushed for are over now. We're going back, right? And where he's made it clear that he has a big focus on attacking certain news organizations and promoting others. And we're seeing that he's really pushing on any news organizations that are saying things that he likes and saying that he's great, those we're seeing sort of get preferential treatment. And so I think all of that is going into the consideration of whether to settle or not. I don't know how much of it really has to do with the merits of these cases, right? I think news organizations are seeing what's happening in the culture, seeing how our new president is behaving and making decisions based on those calculations, perhaps even more than they are based on what would eventually happen in court.
So, Caitlin, talking back to the or moving back to the allegations in this case or these cases, you mentioned the PR battle and how important that is in this kind of conflict. And in this case, I think we've seen, more inside disputes that we've seen in recent memory. Perhaps like Johnny Depp versus Amber Heard was another example, but this is again one of the most played out conflicts that we've seen, at least in the film industry. And specifically, there's been many texts revealed. There's been Justin Baldoni over the weekend set up a website that the public could access.
Yes.
To the point where Blake Lively and Ryan Reynolds' team have asked the judge to impose a gag order. Mm-hmm. Justin Baldoni released last week or maybe 10 days ago a long video, I think 20 minutes of some of the filming where he wanted to show the public and perhaps a future jury pool that this supported his position that he could not have sexually harassed Blake Lively because she was a willing participant in this particular piece of film. She, on the other hand, quite interestingly, came out and said this supports her position. The same video supports her position because it shows that he was sexually harassing her by asking her, by trying to kiss her and telling her that she smelled great. So I know it's a long buildup, but how important is this PR war more than perhaps the substance of these allegations, or maybe equally as important?
I think it's been a huge driver for how particularly Baldoni lately has been conducting his, how his legal team's been making decisions and what they're choosing to do. I don't know that anybody on his legal team thinks, of course I can't know what's in their head, but I wouldn't guess that they think that the court is going to be happy about what they're doing, right? I typically you see judges have a lot of respect for the judicial process because it's supposed to lead to an orderly finding of the truth. The answer we're trying to get at the end is what happened and what is the right outcome based on these facts that we have all determined and all decided are the facts, right? There might be two different sides saying, here's a set of facts, but ultimately you're going to have a trier of fact say, this is the final set of facts. Here's what happened. That's it. And then let's make a decision and go forward. And you do it in that way to make sure that both sides are getting a fair shot, right? And being able to get access to the courts without having a threat of having whatever they're complaining about be made worse in the meantime. So they've already brought up this idea of a protective order that they're going to have. They've asked for the gag order in the meantime. And whether they get it or not, what we're definitely seeing is that Justin Baldoni's legal team is definitely handling things differently than we usually see litigators handle things. Like this website, I've never seen anything like this. Come to the website, see the complaint, see all the evidence. And I know they're saying this is all publicly available information that you could get on the docket. Okay, maybe that's true. But they're clearly trying to draw the public's attention to it on a nearly daily basis in a way that you don't normally see. And so I think what Lively's team is trying to do is just like slow that down and say, let's get back to sort of the litigation basics here. And it's interesting too that you brought up the Johnny Depp Amber Heard trial because that involved the same PR team, right? That's at issue here with Justin Baldoni's PR team that's been drawn into all this. And we've seen their text messages about, we can bury anyone. And they were involved in the Heard Depp dispute as well. And so, we see some repeat characters here being in the middle of these really big public stories.
Yeah, it's a great point. What do you make of the claim damages here? I think Baldoni's ask is $400 million in his defamation claim. I think it's safe to say most people have not heard of Justin Baldoni. He's certainly not a
Right.
well-known filmmaker or actor. This film did pretty well. So I understand, his allegation that this has caused him and will cause him to lose professionally. But, where does he come up with 400 million, and what do you make of that allegation?
Yeah, it sounds like a lot of money um, to most of us, as it should. And I think we'll see how he tries to prove that up. So in a defamation case, you have generally two routes to get compensation for a claim if you're able to prove it. And one is through what we call special damages. So it's where Justin Baldoni's team would be able to prove he had X particular opportunity and he lost it because of this reputation. And that would have gained him, $100 million. But because of all of this, that, the New York Times article and everything that Lively has said, he wasn't able to take on that project. So there's $100 million gone. That's special damages. And so you have to connect directly, the causation from he was defamed, that money was lost, compensate me. And then the other option that you can get damages for, and you can actually get both, if you're in certain cases, is general reputational harm. And so when you have a particular claim where general reputational harm is available, you can just say, my reputation was harmed. And so, you can introduce evidence showing that you suffered and um, showing that certain people see you differently, or argue about how, of course, if anybody read this, they'd think more poorly of me. And then you just let the jury decide how much money that's worth. $400 million sounds like a lot for this particular issue, but maybe they have particular projects that they're planning to point to, or counting on the jury to say that the overall harm caused to his reputation was worth a lot of money.
On the flip side, there's way more notoriety about this film and probably eyes viewing it because of this controversy than there would have been without it. So that's
Yes.
an argument probably in mitigation of those damages. Last question we have: how do you see this ending? I mean, most of these cases settle rather than endure the, as you referenced earlier, the cost and expense of litigation. How do you see these competing claims ending?
Yeah, it's a great question. I'd say with respect to the California claim, I'd like to see New York Times stick it out, and get to the merits of it. I think there's some possibility that it gets ruled on by the court at the motion to dismiss stage, gets kicked out at that point. It's possible that that doesn't happen, right? And if it gets past that and they do have to go into discovery, I'd say anything could happen at that point. But uh, I think we'll know a whole lot more once New York Times files its initial motion. In New York, you know, I think that Baldoni's team right now is looking for all the press that they can get around it. At least it seems that way. And so they're probably okay with keeping it going for a while until they feel like they've gotten everything out of it that they can. Um, and maybe that happens soon. I mean, the fact that we're getting new news about these litigations every 24 hours, it seems, might mean that it all plays out in their eyes pretty quickly. But I'd say probably once each side feels like, that we've done all we can from the PR perspective, uh, the hope would be that it kind of settles and everybody can go forward with their lives. Um, that said, if either side truly does feel that they have been very wronged and they want the court to decide that, um, a lot of times we see litigations go on for a long time, not because of the money, but just because people want to have some kind of formal public acknowledgement that what they suffered was wrong, shouldn't have happened, and get that kind of indication. And so if those sort of emotions prevail on either side, I think it could go on for a long time.
Caitlin Kovacs from Benish Law. It's benishlaw.com. Thank you so much for joining us on the SERMAPod.
It's been so good to be here. Thank you for having me.
Appreciate it.